Good evening, everyone, and welcome to our questions and answers forum. So we begin with a word of prayer. Heavenly Father, we thank you for the gift of knowledge and the opportunity to prepare for this important journey towards 2025 Law Contract Examination. Give us clarity of mind, diligence in study, and humility to learn. Bless our discussions today, that they may sharpen our understanding and guide us towards wisdom. Entrust our efforts into your hands, knowing that success comes from you alone. Amen. So this is what we are going to do in the first part. I'm going to give the opportunity for you to raise some, whatever is challenging you. So we discuss together before we move on. So if you want to uh, make any contribution, just raise up your hand and then you'll be allowed to speak. The mics are locked, but when your hand is up, the mic will be released for you so that we don't have background noise coming into the class. Thank you. Yes, baby neighbor.
Uh, uh, Good evening, my lord. Please, my question would have to do with how the law has evolved in regards to stool land alienation. I don't, and also the if a member of a stool can sue the stool occupant, or like in the case of Kwan versus Yeni. I'm confused with the case of Usu, Jeff versus Usu and Usu versus AG. I think I have a little bit of confusion with that area. So if you could help by clarifying the
Okay,
inroads that
all
has
right,
been. Thank
all
you.
right. Baby, thank you. The Kwan and Yani principle. Okay, in the past, there used to be a long line of jurisprudence or case law as to whether a family member can actually sue or take a legal action in respect of a family property or stool property, as the case may be. And the case law uh, was to the effect that that could not be. And later on, as you will notice, because of the injustices associated with that, when the PNDC did their revolution, there was what we call the head of family accountability law. So that was like the only instance in which a family member could, for example, uh, a family member could hold the head of family to account, but that has changed. It's not right now, it's not just head of family accountability. Any family property or stool land where somebody is trying to make a trespass or laying adverse claim to it, uh, if and the head of family, for example, or the stool, as it were, does not appear to be interested or to be acting, any member of family who is aware, or stool who is aware of the suit, may actually take it up or pursue the litigation. However, if you look at the rules of course, CI 47, I think under order 4, I don't have my rules with me where I am. It is the law that where you are not the head of family and you take up a matter on behalf of the family or the stool, you are required by law to serve a notice on the head of family so that if the head of family is uh, mindful of doing the needful as a head of family, that he or she will come and join you or take over and pursue it on behalf of the family that owns the land or the stool. Now that is an improvement upon the Kwan and Yani principle. So that has been codified now, and it has a legislative footing. So it's not just like a case law. So that is the position. So the takeaway is that where there's a problem, like somebody laying a claim or adverse claim to a family property, and the head of family, for example, is not acting, then the law allows a family member to actually take up the matter, but the law requires a notice of what has been done to be said on the family member, so that if the family member wants to do what is expected of him as a family member to protect the property of the family, that can be done. He can take it up, or if he doesn't take it up, the family member will continue to pursue the matter. Yes, so that is about it. Yes, let me see. Let me release. Yes, Nancy.
My lord, please, I want to know between the contract topic of misrepresentation and its equivalent in torts. I
The
know of
contract of, say that
uh,
again.
the vitiating factor misrepresentation,
Yes,
yes, and its equivalent topic in torts. I know of the three types of misrepresentation in contracts. That's the fraudulent, negligent, and innocent.
right.
I'm conflicted a bit. In thoughts, I know of misstatements. I don't know if it's negligent misstatement or misstatement
Oh,
only.
right, right, right,
And
right,
that if it's just only one as
right,
compared to the three.
right.
Thank you.
Thank you, Nancy. Yes, good. So, as Nancy rightly said, misrepresentation is a vitiating factor. When we say vitiating factor, that is to say that it affects or undermines the genuineness of consent, which is supposed to underpin a contract or agreement. And as she rightly said, we have negligent misrepresentation, fraudulent misrepresentation, and innocent misrepresentation. And then she would like to know whether negligent misrepresentation connotes the same idea as misstatement when you are discussing law of tort. The answer is yes, it's the same. The answer is yes, it's the same. And in fact, the same authority which we use, and you might do, as far as misrepresentation is concerned, until the case of Hedley Brand against Heller and Partners was decided in the early 60s, uh, misrepresentation was of only two kinds. It was only what we call the fraudulent misrepresentation and innocent misrepresentation. Negligent misrepresentation had not really crystallized as a distinct form of misrepresentation. So in Hedley Brand against Hedley, against Helen Partners, as you remember the story, somebody and the company was actually going to request for advertising to be run for it at an on-credit basis. And the advertising company needed to know the credit worthiness of this particular company, I think called AC Power Limited, which was supposed to benefit from this advertising services. So it requested the bankers of this uh, company to do what in modern times we call the credit check for it. And they wrote an opinion that they were quite positive that it was a credit-worthy company, meaning that it is safe to uh, run services on it on credit basis. Fortunately for them, they inserted what they called a disclaimer. A disclaimer, simply saying that despite all the things I have said, please, I am not ready to be held liable. Okay? So I don't want to take responsibility for any of the advice that I am giving you. Good. So that was it. Now, so they went ahead to run the advertisement on credit basis, and not too long after that, this company, which has enjoyed advertising on credit basis, and then became bankrupt or insolvent, and it couldn't pay its debts, including the advertising had enjoyed on credit. So the company which had rendered the advertising services sought to sue the the financial advisors that had given advice that this was a credit-worthy company. So question arose as to whether liability could be fixed on them. And it was within that context that the court actually discussed that if there's a relationship between parties which is based upon trust and confidence, and the other party, for example, knows that the advice that you are going to give or the information is going to be used for some decision or some transaction, then you have a duty to exercise requisite care to ensure that the advice that you are giving is accurate. Otherwise, if you don't do that and it is relied upon and something should go wrong, you'll be held liable for that. But fortunately for them, because they had inserted a disclaimer, the court took the view that even if they had the duty of care, the disclaimer had actually negated any such liability. So the takeaway is that Edlebrand against LM Partners, and later on clarify in case like Capero and Dickman established the proposition that there can be a duty of care where there's a financial relationship, or where the proximate relationship is such that the other party ought to know that the other who is going to receive information he's providing, opinion, will expect him to have exercised a requisite care. Otherwise, if something should go wrong, he'll be held liable. So the same thing also applies in negligent misrepresentation. You look like cases like Esso, Petroleum, and Marden. Those cases where somebody is buying maybe like a filling station, like a petrol station or something like that, and then they want to know the capacity of, let's say, like in terms of like the safe's viability, or somebody is trying to buy a mine and they want to know like the capacity of what can be. And let's suppose that information is provided that this can do so much, and that information is used to make the decision. Now, the position of the law is that if the maker of the statement, okay, was an expert or someone who was making it from the position or point of view of like an expert or an experienced person, then the law will place a duty of care on that person to ensure that the statement is accurate, except where the party appears not to have relied on that statement, but to have relied upon his own independent assessment or something like that. Yeah, so in that respect, there is that similarity, was the same point which is done. In fact, where a contract is vitiated, the law is that there is no valid contract properly so called because of the, let's say, the misrepresentation, as the case may be. And the misstatement, which is recognized when we are talking about tort, is the same as what we mean by the negligent misrepresentation, as it were. Maybe the only difference will probably be that negligent misrepresentation oftentimes is at what we call the pre-contractual stage, meaning that the misstatement in that particular context is made maybe as part of information somebody is eliciting before he or she will enter into a contract. And the contract in this case is supposed to be with the maker of the statement. But if you look at the misstatement as a species of tort, simpliciter, no contract need to have been entered into with the maker of the statement. But in the case of, let's say, misrepresentation, the the misrepresentation definitely will come to the representator who is supposed to be like the other party to the contract. But when we are talking about torts in general, the maker of the misstatement ought not to have really entered into, if you like, a particular a contract with that person. And the basis of the liability is not so much about the contract. The basis of a liability is about the proximity of the relationship, the fiduciary nature of the relationship. Nancy, I don't know if that assists you. Okay, she's gone, but okay. Yes. Any, yeah, okay, Ben hand is up. Yes, Ben.
Hello, sir. Thank you so much. Actually, this is Bibiniba. Because of the difficulty, I had to change the name to my original name, Benesian.
All
Yes,
right.
yes. Please, my question earlier was on the inroads that has been made with regards to alienation of stool land, where the occupant of the stool public alienates the land alone without the consent and concurrence of the principal members of the stool, and also whether the principle in Kwan versus Yeni can be extended to stool land, or at least stool occupants, with regards to Jenfi versus Owusu and Owusu versus AJ.
Okay, so tell us what happened in Gemfi versus Owusu.
Okay, so please, it's one case, but was substituted later on, and it was about chief, or at least it's two occupants receiving compensation and also giving out land, selling lands and other things. So I think there were issues of fraud, mismanagement, and other things in regards to the alienation. And a family member wanted to make claims on that, but they said he's not the rightful member to uh, bring out the suit unless the stool occupant. So it was about a stool, a member of a stool making, or let's say, making a litigation
On
with
behalf of
regards
the
to
stool.
on behalf of the stool. Yes, please.
And what was the holding of the court?
And one of the case, I think I'm a little bit confused with one. I don't know if it's the Jenfi versus Owusu. It stated that the principle in Kwan versus Yeni cannot be extended, but that one, the other one, Owusu and AJ, I think it was that when it is when it's proven that there is mismanagement, fraud, and other things with regards to the transaction, or at least with regards to management of the stool property. A stool member, a member of the stool, can
Okay,
bring an
let
action.
me help you. I think I have the case before me. So
Okay,
with
thank you.
respect to the Kwan and Yeni, I think the Azukrab and Co giving the judgment said that referring to Kwan and Yeni, counsel invited the court to extend the exceptional circumstances adumbrated in the case to stool property. The customary law ruled that an occupant of a stool could not be called upon to account did not apply to this case. The suit was originally against the three defendants. It was a court of appeal that ruled that co-defendants should be joined in this personal capacity. So the general customary principles of non-accountability of stool occupant did not apply in the Kumawu traditional area. There was sufficient evidence to that effect that there was such a custom, that the chief was accountable, although it had fallen into disputed. The custom was not dead. Statute could not be used as instrument of fraud, and although there were no legal textbook to support the custom in Kumawu, the court should rely on the records as to the exception in the Kumawu traditional area. But we see, coming back to whether the principle in Kwan and Yani can be extended to stool land, don't let us forget that a stool we have like a stool family. Okay. So if you have like the stool family, uh, members of the stool family, that is the royal, so to speak, they can bring themselves within the Kwan and Yeni principle, which has been codified in the CI 47. I don't know if that sounds clear to you. The mic is low. Yeah, Ben, are you on? Ben?
Yes, please. I was muted. I was not able to mute
Oh,
myself.
okay.
Yes, please.
Okay.
So please, it's clear. Thank you
Okay.
so much.
All right.
Yeah.
Who else? Okay.
Hello, sir.
Yes,
Please,
yeah, yes.
I think that the first part of it too was alienation made by the stool occupants alone, without the concurrence and the consent of uh,
No,
others.
that position of the law has not changed. If under the Land Act 1036, the position has not changed. Uh, the occupant of a stool alone cannot make a alienation. And I hope you have your Act 1036.
Yes, please. I have it.
Okay, let's get the provision. Section 9. You see, the other point we should remember is that if you look at Section 9 of the Act 1036, the Land Act, a stool or skin or clan or family line shall vest in the appropriate stool or skin or clan or family on behalf of or in trust for the subjects of the stool or the skin or members of a clan or family in accordance with customary law and usage. So what that means is that the customary law principles regarding alienation are still applicable, and there is no crystallized case law which says that it is no longer the case that when the occupant of the stool or the skin is making alienation, he doesn't have to do that with the consent and concurrence of principal members whose consent and concurrence are required for valid alienation. Unless you want to point me to a case law which I am not familiar with, then we will listen to you. Okay. Yes. Any other? Yeah. So I notice they're really prepared for 12 I should go and watch my movies. Okay, there's a hand up. Okay. Let's take Mas, and then after that, Fidelia. Yes, Mas Hoodie. Yeah. Okay, if Mas Hoodie is not ready, maybe Fidelia Domi can talk.
Hi, sir. Okay, there's this question that I don't really get the understand if you can help that a lease agreement is as good as a lease. I don't really get the meaning. If you can just help me with that. Thank you.
Good. So the question is usually an agreement for a lease is as good as the lease. An agreement for lease or a contract for lease. An agreement or contract for lease is as good as the lease. So that is against the backdrop of a case we call the rule in Walsh and Lonsdale. And then is that case law which establish that proposition. And what it means is that, usually when you're doing like the conveyance or when you're doing the document for transfer of interest in land, it's usually two-stage. The first part is what they call the contract stage. That is the contract for sale of interest in land or contract of sale of interest in land. That's the first part. And then the second part is execution of the conveyance. That is what you call like the deed of lease, the deed of assignment, the deed of sublease or whatever. Okay. So that is the second part. So what happens is that where the parties have reached an agreement that yes, the vendor, the grantor, the person having an interest in law, has agreed that in consideration of whatever consideration they've agreed upon, which the grantee, the purchaser is providing, he or she is prepared to alienate, an interest or to make a grant of interest in land by way of a lease or sublease or assignment. Now, that is done. That will have to be carried into effect by doing the formal document called like the deed of the lease or the deed of the sublease, as the case may be. So when we say that an agreement for lease is as good as the lease itself, that is to say that in the eyes of equity, as reflected in Walsh against Lonsdale, the position of a court of equity was that despite the fact that the parties had only an agreement for lease, as we have explained, it has not been officially reduced into a formal form as like the deed of conveyance, equity regarded the lease as having the lessee, that is the prospective grantee, the lessee, as having the same rights and obligation as if the lease had actually been executed. So despite the fact that the formal lease has not been made, equity will give you the protection which is given to the lessee if the lease had actually been made. And what that means is that specific performance can actually be decreed. Okay, so that let's say that later on, if the lessor decides not to go ahead and get the lease executed, the court can actually decree that specific performance should be issued to compel him to fulfill his obligation under the agreement.
Okay, yes, thank you so much. And is there any limitations to that? Like under the equity, is there any limitation?
Of course, all the requirements of a contract, should be present, consideration should have been provided, and so on. There should be certainty, then the rules on limitations, as under the, let's say, for example, the limitations decree should, for example, not have actually, kick in. And we know if we look at the repealed conveyancing decree as we have under the Act 1036, especially Section 3 of the repealed one, as reenacted in Section 12 to 15. So if you look at the Section 12 to 15 of the current legislation, you will notice that where you have a lease of more than 3 years, then it's required to be in writing. So that if the agreement is not in writing and, for example, they cease that particular period, then you'll not be able to take advantage of the principle that an agreement for lease is as good as the lease itself. Because here we have a statutory requirement which says that if the contract or the agreement is going to transfer an interest for more than 3 years, then it should be in what? It should be in writing. So then that will have to be respected. So those are some of the restrictions. And of course, anytime we're talking about equity or the maxims of equity as appropriate are applicable. And we say the equity consider as done that which ought to be done. So if you have like an agreement for lease and it is a precursor to the drawing up of a lease, then equity will treat the parties as if the lease has actually been concluded, of course, subject to any statutory modification like the limitations that I mentioned.
Okay, thank you.
Very well. Leonora.
Good evening, my lord. Please, can you please go over or no, like, can you please make the principles in, can you please explain a little bit or probably simplify the principles in Baker versus Carr for
Principle
us?
in what?
Baker and is it Baker versus Carr under political question? Is it? Yes.
Baker.
And Carr. Or let me.
That's American jurisprudence. Yes. What does it done?
I'm saying that you see, it gives the requisites for which one can bring under the political question doctrine.
Okay.
So I was asking if you can explain it a bit for me, like the English in Baker versus Carr, it's a little bit confusing. So if you could simplify it a bit for us.
Oh, okay. I think what happened in Baker is similar to some of the current debate going on in the US. What you call the boundaries or like the districts. So in Baker and Baker is a case from the state of Tennessee, and the facts indicate that the state of Tennessee had not redrawn its legislative districts since 1901, despite the fact that there had been significant population increase and population migration. So usually US, and of course, just like ours too, under appropriate conditions, where the population actually increases, you need to demarcate, let's say, the constituency. So over there, like the districts. And for that matter, there was a problem of having uh, rural votes carrying disproportionately greater weight than urban votes, meaning that those in the rural areas more or less were supposed to have more say in terms of the votes, the weight which their votes actually carried. And there was this concern that it unfairly undermined the principle of one person, one vote. So they brought up a suit to challenge it as a violation of what they call the Equal Protection Clause of the 14th Amendment. And an argument was deployed by the state of Tennessee that what was being actually challenged was a political question, and it was not for the courts to decide. So it's not justiciable by the courts. So that is the idea about the political question. So when we say political question doctrine, just trying to say that the matter being presented is a matter which is not within the domain of the court, is not justiciable by the courts. And it's supposed to be an aspect of separation of powers. The fact that the three arms of government, each of them is endowed with their proper powers and functions. And of course, despite the fact that we don't have a strict separation of powers and some hybrid, that notwithstanding, as far as practicable, that each organ should stay within its proper domain. So trying to deploy this political question doctrine argument, it was to the effect that certain constitutional issues are inappropriate for the judges or the courts to deal with. The reason being that if you look at the Constitution, they are textually committed to a particular branch of government, such as maybe the executive or the legislature. And for that matter, the courts lacks the standards or the ability to be able to deal with them, except the particular arms of government that have been entrusted with that responsibility. So in the US, that principle actually gained ground even beyond the Baker and Carr in subsequent cases like the Luther and Borden. And the court in that case will even say that if we look at the Republican form of government, not having a monarchical form of government, as guaranteed by Article 4 of the Constitution, it meant that there are certain matters which are properly left for, let's say, the lawmakers like Senate, House of Representatives, and not the judiciary. But if you look at the case report available, there was a dissent, or there was a split. We had some judges who took the view that the case was justiciable and was not made non-justiciable by the so-called political question doctrine. And the reason that where there had been inappropriate drawing or where there be inaccuracy in the drawing of the legislative district, that could be reviewed by the courts under the Equal Protection Clause of the US Constitution. So the court said that it was important to draw a line between what we call the non-justiciable political question and justiciable constitutional norms, as it were. And Justice Brennan propounded a test which will help us in recognizing whether a political question exists in a particular case, for which reason same should be declared non-justiciable. I'm just speaking with reference to the US Constitution. I'll come back and talk about whether it's applicable in Ghana. So the criteria developed was that, one, is there a textually demonstrable constitutional commitment of the issue to a coordinate political department? So if we look at the text of the Constitution and the particular matter has been properly assigned to a particular department or entity under the Constitution, then that is a red flag as well as political question, but we are not done. Secondly, a lack of judicially discoverable and manageable standards for resolving it. If we look at the nature of the issue, can we say that judges lack the capacity to be able to actually resolve it or deal with it? Thirdly, the impossibility of deciding without an initial policy determination of a kind, clearly for non-judicial discretion. In other words, is the issue such that you cannot decide it unless you make some policy choices, policy determination which actually do not relate to judicial discretion. Fourthly, the impossibility of a court undertaking independent resolution without expressing lack of respect due coordinate branches of government. So if there's a risk that if the court is to pronounce upon it, the court may actually be veering off into an arena which is meant for a particular organ, and that may be sort of like a disregarding the proper mandate of that particular organ. If that risk is there, there's a political question. Another point is that an unusual need for unquestioning adherence to a political decision already made. So if it is said that the courts are going to question a political decision which had already been made, if the matter is to be dealt with, the matter will be resolution of it to be said that the court will actually have to be critiquing the political decision which has been made, and that is there's a red flag. And again, the potentiality of embarrassment from multifarious pronouncement by various departments on one question. So if those things are there, then you say that the matter is a political question, and for that matter, the court must declare it non-justiciable. Now, if you come to Ghana, we need to be very careful about Baker and Carr, and then all the jurisprudence on political question doctrine, especially from the US. And the reason being that, and all the time we have to remember, how the US got the principle of, judicial review. Because of Marbury and Madison, you know the story too well. Marbury and Madison, remember the story of Chief Justice Marshall, how the US Constitution had not explicitly, enshrined that the US Supreme Court or the US Court can actually exercise review over decisions and work of the other organs of government to ensure whether they are in tandem with the US Constitution or not. That is not quite explicit. And you have to take the ingenuity of Chief Justice Marshall in trying to read the provisions vis-a-vis the functions of the various organs of government to say that the fact that you have like a written constitution, the fact that all the organs of state have their function, and if nothing is unclear, it is for the judiciary or the court to tell us what the law is. Then it means that necessarily the court must also have the power to determine whether the other organs of state have actually acted in accordance with the US Constitution or not. And that actually led to the development of what they call the judicial review of other legislative or executive acts under the US Constitution. And because of how sensitive it was, the courts were very careful not to create a constitutional crisis for there to be a collision course between the judiciary, the executive, and then the Congress on the other hand. So the court itself sought to police itself in trying to not vex or not, provoke the other organs of government so much. And they did that by, such mechanisms as political question doctrine, doctrines like mootness, ripeness, and so on. That way, the court was able to use the power of judicial review, which it had asserted in its own way in a very careful and sparing manner. So that is the background which we have to appreciate. Now, in our part of the world, in our constitution, our story is different from that of the US. So we need to be careful and not jump to conclusion that political question doctrine is applicable. Political question doctrine, in the sense as I have explained from the US, is not applicable necessarily to our context. Of course, our equivalent would be the directive principles of state policy, where there used to be argument as to whether they are justiciable or they are not or justiciable, having regard to their nature. And the Lotto case and subsequent jurisprudence, where the court said that every aspect of the Constitution is justiciable, and even the directive principle of state policy, where there used to be a view that unless you can locate corresponding provision in the chapter 5 of the Constitution before to the extent of the correlation or the corresponding between, you will say that a directive principles of state policy is justiciable. That notwithstanding, the predominant view is that the whole Constitution is justiciable in appropriate parameters. So therefore, the political question doctrine does not really arise. But of course, that is also not to say that the courts are not mindful of separation of powers and matters which properly belong to the other organs of state. And as we have seen recently in the two cases related to the or the proper human sexual values bill, as you remember, the two cases we've discussed before, where the court was careful to say that yes, under Article 93(1)(06), the Parliament has the power to make legislation, but then we cannot rush to invoke Article 2 and Article 130 to exercise our review powers over it, where the power of Parliament has not been exercised to its final stage. Its final stage is where the President has actually signed the bill and then has become an act of Parliament before you can go to court and say that, in your view, that act is violative of an aspect of the Constitution, as it were. So those are some of the things which we have to appreciate. I don't know if that assists Lenora.
Yes, my lord, it does. Perfectly clear.
Okay.
Then I have a follow-up question, which is on land law. My
Okay.
lord, please, what is the current position when it comes to spousal properties, the exceptions of spousal properties regarding loans
Okay.
acquired during on a property?
Okay. All right. Good. When it comes to property law, particularly spousal property law, that is property acquired by married couple. There has been some confusion in our law for a long time. And the confusion has been this, that when people are married and property is said to have been acquired, where there is a divorce or where one of them dies and issue arise as to how to distribute the estate of the deceased one, how do we determine properties which belong to his estate and not a property, belonging to, the couple as a couple and so on. So what is a spousal property? The confusion in the past used to be that we can call a property, jointly acquired matrimonial property, where both parties have contributed towards its acquisition. And the contribution here in the past used to be financial acquisition, or if you like, a physical, tangible acquisition. And if that could not be demonstrated, then the property could not be said to have been acquired jointly by the couple. Now, fast forward, we had our. Please don't go and write fast forward in your answers. Okay, this is just a colloquialism, just a spoken English. So don't be writing those kind of slangs in your answers. Yeah, so we had our constitution, which came into force, and the constitution, as you remember, I think Article 22 of the constitution, where I am, I don't have my laws around me. Article 22 of the constitution or so has actually provided for spousal. Is that Article 28? 22? Those who have the constitution?
Yes, please,
It's
22.
22. Good. Yeah, so Article 22 had provided that Parliament should enact a law which will govern distribution of, property among couples and so on. Now, that law has not been made by Parliament for a long time. So cases came before the court, and the Supreme Court, uh, following cases like Mensa and Mensa, Finn and Finn, and J, will say that if we look at the provision of the Constitution, there is a presumption of equality. That is to say that where the parties have, people who are married, they've made the property, there's a presumption that they acquired the property together. And it was not necessary for, you know, let's say the woman or the other party to prove that I contributed so much, this amount of money. And then the court said that if you look at contribution is quite broad. It includes, the support that the couple provide in domestic setting, like the woman taking care of children, doing the household chores and so many. So all those things are part of the contributions, which for which reason it makes sense to have the position that once you have a property acquired during the subsistence of the marriage, it is presumed that it was acquired by both parties, and for that matter, it's supposed to be shared equally. But later on, the Supreme Court seems to be changing the position that saying that there's a presumption that the property belong to them does not necessarily mean equality of sharing. And where evidence is available, we need to look at the particular contribution made so as to decide the fair ratio or proportion in which the property may be split between the parties. So that has been the jurisprudence around that. Now you come to the Land Act. The Land Act requires that where you have like property between couples and you want to dispose of it or use it for any transaction like that, you must actually get the written consent of the other party before the transaction will be valid. Meaning that if a spouse, for example, should use the matrimonial property to go and raise a loan like a mortgage and so on, and the other party, the other spouse, will actually not sign, approve it in writing, then that is not valid. Yeah, so that is one thing that we should remember. There's an explicit provision in the Land Act 1036 to that effect. Which provision is that, section what? I suppose you have the Land Act now on your fingertips. Section what?
My lord, the question again.
Which provision of the Land Act requires that a spouse should consent in writing before spousal property or matrimonial property can be disposed of or used to raise a loan?
I think
my lord,
section 38
47.
or something. And I remember.
Section what? There's a provision at 1036 to that effect. Is what? Section? Read it.
My lord, section 47.
47. Oh, okay. Let's see. Section 47. I don't have the restriction on transfer of land by spouse. Okay. So, except as provided in subsection 3 and 4 38, in absence of a written agreement to the contrary by the spouses in a marriage, a spouse shall not. Where is that? Yeah, a spouse shall not, in respect of land, right or interest in land, acquire for valuable consideration during marriage, sell, exchange, transfer, mortgage, or lease the land, right or interest in the land. B. Enter into contract for sale, exchange, transfer, mortgage, or lease, right or interest in land. C. Give away the land, right or interest in land inter vivos. Or D. Enter into any other transaction relating to the land without the written consent of other spouse, which consent shall not be unreasonably withheld. Yeah, so that is the position of the law. So let's keep that in mind. Section 47. Yes, so Lenore, I think that is it.
Like, my lord, my question, in as much as this has been helpful, you see, during the distribution of the properties, when the couple are being divorced, I'm asking the position of the law where the subject matter of the property is backed by loan, like where one has
Backed by what? Loan?
yes, like where the subject matter of the
Oh, okay,
property.
good. So let's say that the loan, one of the parties or both parties went for the loan.
Yes, please. And
Okay,
the loan
so
has not been fully paid during the pendency of the divorce. Are they supposed to share the properties? Or what I used to know was that where one of the spouse had not finished paying the loan, the property involved is left to the spouse that is not done paying the loan. So I'm
No,
asking, what is the current
no,
position now?
no. There has not been any position of the law like that. It depends upon the circumstances of the particular case. So if the loan was taken, okay, let's look at the number of scenarios. Scenario one, the husband tells the wife that he's taking a loan to buy a land or to continue with the work on the land. So the wife knows that the loan was taken towards the property, or the wife did that, or both parties go to take a loan uh, as part of working on the property, or even if not that, the loan is taken and the loan is not actually used on, let's say, the house direct, but then the loan is acquired in the knowledge of the other spouse. If one spouse goes to take the loan, the other one does not know about it, it will be difficult for you to expect such a loan to be treated as affecting the joint matrimonial property. So that is very important. Otherwise, there will be fraud on the other spouse. Okay, Lenora?
Yes, please.
So where a loan has been taken by spouse A and spouse B is aware of it, then if there's a divorce, we need to adjust assets and liabilities. It is a net asset, which is going to be treated as a matrimonial property, which needs to be split between them. Yeah, Nancy, your hand is up. Or the old one.
My lord, please, I need clarification on 130, Article 130 clause 2.
One
The referral, yes, the referral, where you have to refer if a matter of interpretation comes up from the High Court.
Okay.
I know that from the McCann principle that if it is clear and there is no ambiguity, you need to apply. But then it was, I've also read in the ex parte Zanito that you do not know that it is clear. So how would you be able to tell that it is clear unless you refer? So I'm a bit conflicted looking at the two positions. At what point would you know that there should be a referral, that you will have to refer, or better still, go with the Mekankan principle? And then two, the decision in Osei Boatin, as Emmanuel Noboko, the court said that after every decision made after Emmanuel, after Osei Boatin must be done away with. I want to know that particular ruling, the concept, or at what point did the court do, or are we supposed to go just like that, or there is an explanation to it? I don't know. I'm just confused as to them.
Okay, I think you remember, as you rightly said, Osei Boateng and also the expert Yakusa, the principles which were set out there for us to know whether there's a case for constitutional interpretation. We discussed that in previous lessons, and the recordings is there. So where there's a matter before, let's say, a high court or circuit court or even a court of appeal, and an issue of constitutionality arises, the court will have to, there are two schools of thought, but the predominant one seems to be that where the constitutional question comes within what the criteria let's set out in the Akusa and then judicial imprimatur given in Osei Boateng and call those line of cases, then the court will have to state the constitutional question for Supreme Court to answer. proceedings will be stayed. Then, depending upon the outcome of what the Supreme Court will say, the judge will use the pronouncement of the Supreme Court to continue in resolving the matter before it. Yeah, so that is it. But there's what you call the risk of abuse, that almost every, you can get a lawyer who will turn every case into a constitutional case, warranting a referral to the Supreme Court. And that is where testing the appropriateness of the constitutional question raised against the factors canvassed in those jurisprudence become important. Because otherwise, you can get a lawyer who wants to just delay matters and frame everything as warranting constitutional interpretation. So does it mean that as soon as somebody says that something warrant constitutional interpretation, so it is, and then the trial court must actually make a referral? No. Even as to whether it warrants, that point will have to be argued before the court for the court to see the constitutional position being canvassed. Then a referral is made to the Supreme Court. Yes. Any other? Yes, Juliet.
My Lord, good evening.
Good evening.
Okay, my question is on chieftaincy,
Okay.
cause of matter affecting chieftaincy. Please, my Lord, my question is that when the matter gets to the National House of Chiefs, and maybe the person is not satisfied with the outcome and wants to go to the Supreme Court, is it as of right, or you seek leave of the National House of Chiefs before you can proceed to the Supreme Court?
Oh no, if it started from the original House of Chiefs, it's as of right. You don't need to seek leave. Yes, Juliet.
My Lord.
Oh, sorry. It's Mr. Lincoln. Yes. Do you have a position which says that you have to seek leave? Let's know.
I'm talking about the National House of Peace.
Yes, so the National House of Chiefs has decided the case, correct? And you are not satisfied, and you need
Yes,
to appeal to the Supreme Court as to whether you should get a leave from the National House of Chiefs before you go.
yes, my Lord.
No, no, you don't need to.
Okay, so it's
Yeah.
as of right.
Yes.
Okay,
Is
all right.
that when, let's say that if you are doing like the normal courts, where a matter start below the, let's say the high court, let's say a case started from the like from the district court, let's say civil case, okay? Civil case started from the district court. You are aggrieved by the outcome, you want to appeal, you go to the high court. You are still aggrieved, you still want to appeal again. Okay, you go to the Court of Appeal. After Court of Appeal, you are still aggrieved, you want to appeal again. Supreme Court. So here, you have already enjoyed two levels of appeal, High Court and Court of Appeal. So the law is that if you want to appeal again to the Supreme Court, you must get a leave of the Court of Appeal before you can go to the Supreme Court. And where the Court of Appeal refuses the leave, you can go to the Supreme Court and argue for the leave for them to allow you to come and appeal there. So you are supposed to, and just like the National House of Chiefs, you don't take like cases there directly. The case will have started from the traditional, the traditional council. You go to the Regional House of Chiefs, the Judicial Committee. You go to the National House of Chiefs, and then you go to the Supreme Court. So if you look at it, it's like the two levels of the appeal is still preserved. But where, let's say in the regular court, a matter step from the High Court, you are aggrieved, you go to Court of Appeal, you are aggrieved by Court of Appeal, you go to Supreme Court, so you still have two levels. So we have like a two levels of appeal, if you like. Juliet, I don't know if that assists.
Yes, my lord. Thank you.
And because you mentioned chieftaincy, maybe for sake of Juliet's interest, let me see if I may do a little bit of discussion on chieftaincy for you. So just as a quick brush up, and then I have like a whole discussion on, I think, chieftaincy and the podcast on constitutional law. I think if you go there, I think it's been discussed before as in a regular lecture, not in a revision session like this. So I think if you want more of it, you can look for that. But let me be sure so that you. In the meantime, if someone has any question, you can just bring it up before.
Yes, my lord. Wanted confirmation on the age in terms of capacity for infant, in terms of contracts, the common law and the case of Latte versus Bannerman says that it's 21, and we've also got others saying 18. Of course, the company's law, the land acts, but which is which? In case you get a question like that, which one do you use?
Right, thank you. Yeah, so having regard to the current configuration of legislation, it is safe to say that the age of majority is 18, it's not 21. It's 18, not 21. You know, you take the Courts Act. The Courts Act, that was 1993. That's some reference will have been made to some 21 who are infantis, especially when we are talking about. If you have the Cause Act, if you look at the interpretations, as you know, there's a provision relating to guardian ad litem, okay? Guardian ad litem, and then who is a guardian ad litem? And we go to the interpretation session in trying to define the infant for purposes of the guardian ad litem. We told that someone below the age of then 21. So let's look at the interpretation session. It's been a while. Yeah, so if we go to, I think let's see section 117. You'll get there was a provision which brought about this 21. Of course, at common law, which we receive from England and Wales, the position at the time, Nash and Iman and Chappell and Cooper and all that were decided. The age was 21. That is why we, in our contract, we say that the age of minority or the majority is 21. However, we have moved on. We have a Children's Act, and the Children's Act is a dedicated legislation on children, and it says that the child is someone below the age of 18. So the Children's Act, the Companies Act, when we used to think of the 21, we used to base ourselves, among other things, on at 179, the Companies Code or Companies Act of 1963 at 179. But as we know, that has been repealed. And if you look at the repealing legislation, which has been enacted, Act 992, a child or an infant is defined as someone below the age of 18. And if you look at the Interpretation Act, a child is also someone infant below the age of 18. And the Land Act too. So if you put all these pieces of legislation together, you are not wrong if you say that the age of majority for purposes of contract is 18. In any case, I think if talking to some of the examiners who have marked contract in these exams, anytime they did like marking scheme on capacity, they accommodate this confusion, the 18 and 21. But for now, if you write the 18, I think you are more than welcome to do that. Okay, Elizabeth?
Yes, my lord. Thank you.
Yeah, I think I'm meeting a lot of my students from Wesley University. Congratulations to all those who made it when your results were published. We look forward to you making it to the law school. Yes, Tijani,
My Lord, good evening.
good evening.
Please, my Lord, respectfully, with regards to terms of contract, if you have been given a question or if you have a question with respect to that area of law, is it appropriate to start from oral contract being enforceable, except where specifically it has been stated that it should be in writing? Then you zoom in particularly to the specific angle with which the question actually falls, or it's appropriate to just zoom into that particular area of law. Thank you, my Lord.
Right, thank you, Tijani. Good. To start with, it will depend upon the particular question. Use an essay question. What type of essay question? Did the question say that discuss the difference between implied terms and express terms, or distinguish between conditions, warranties, and innominate terms, also known as intermediate terms? Or did the question says that discuss circumstances under which a court in law would enforce or uphold an exemption clause or exclusion clause? So, discuss, no, yeah, so it very much depend upon the type of question. So we don't have any tailor-made format or any blueprint which should be activated when you are answering all manner of questions. No, it depends upon the type of question. So the type of question will dictate what information you should provide. And that is why the revision that I'll be encouraging you to do, I want you to have basic appreciation of all topics so that you're able to rise to the occasion when any question comes. So terms of contract, again, I've not been doing a lot of lectures because I've been doing this for many years and I have a lot of recordings, so there's no point to be repeating myself. So if you go to my channel, contract particularly, I think I've done, there's no topic which we haven't discussed, okay? There's no topic which we haven't discussed. So terms, for example, I have extensive recordings on it, and I make the point that when it comes to terms, it refers to the content of the contract, what the parties have agreed should be in the contract. And we have two types. We have the express terms and then the implied terms. So express terms are the terms which the parties have themselves negotiated and agreed upon that should form part of the contract. And question is, how do we determine existence of the express term? How do we ascertain whether we have expressed them or we don't have it? We look at two things where you are dealing with oral contracts, okay? So oral contract, how do we determine? It will depend very much upon the use of objective tests. Remember objective tests in your contract. Smith and Hughes, those kind of Tamplin and James, those type of cases. The objective tests using the reasonable bystanders position as to whether a particular statement which was made, was it intended to form part of the contract or not, or it was just meant to be a mere representation, a statement intended to induce the other party to enter into the contract, but not to form part of the contract itself. So we need to determine that. So using those parameters, you'll be able to determine what statements made actually form part of the contract or do not form part of the contract. So please, if you go into my Ghana Law TV channel, and I have a podcast or playlist on law of contract, you can go back and we have the details of that. And again, if it is in writing, then as we often say, the book no lie, isn't it? Once it's in writing, particularly when we are discussing, what they call the exclusion clauses. Now, where you've appended your signature to something, then it's assumed that you intended it to form part of the contract and so on. Then we have what we call the implied terms, terms which are read into the contracts. Not necessarily the parties have negotiated it, but for some reasons, the law says that they should be read into the contract. They should be considered as one part of the contract. Either a statute has provided that, maybe we take like the, for example, Sale of Goods Act. Certain terms are implied. Even the parties don't negotiate; they are supposed to form part. You take the Land Act. When it comes to conveyance, a lease, right? When it comes to a lease, there are certain covenants which are supposed to form part, they imply covenants, whether the parties negotiate or they don't negotiate, they form part of the contract, and so on and so forth. Then they may also be implied because of custom, depending upon the custom and usage within the particular trade. They may be implied there, or they may be implied according to what we call the business efficacy. Remember the well-known case of what we call the Muko case, where the court says that there are certain contracts in order for the purpose of the contract not to be defeated, for the contract to be workable. There are certain things which may be considered as forming part of it, even if the party did not expressly, agree upon that. Remember the ship, the ship which has to stop at a particular side of the river, and there was a confusion as to whether the owner of the port or the jetty was supposed to alert him that the water level was low. In which case, if the ship came, there was a risk of it sitting on the floor and then getting broken on the rock. So the court said that if you have regard to the contract is to enable the vessel to come and stop there or dock there. So how will any reasonable owner of a vessel will certainly not agree to come and park or dock its vessel at a low level water with possibly rocks underneath, and there's a possibility of its vessel getting damaged. No reasonable person would do that. So for such a contract to make a business sense, the court had to read additional obligation that it was responsibility of the owner of the port or the jetty to ensure that the water level was safe before allowing the vessel to come and stop there or dock there. Yeah, so those are some of the things. And of course, you also have to appreciate the relative importance of terms, condition, warranty, and nominate terms. Terms are very important thing in contract, so you have to know it, okay? Condition, term of major importance, which goes to the very roots or the foundation of the contract. When it is breach, the innocent party can treat the contract as having come to an end. He can repudiate it, terminate it, and sue for damages. Warranty, of relatively minor importance. When it is breached, it doesn't affect continuation of the contract. The innocent party can sue for them, but the contract will continue. Innominate or intermediate is a type of contract, type of terms, which is said that you cannot determine its nature unless and until there has been actual breach of the contract. Then the court will assess the impact of the breach on the remaining contracts before it can say that we should give remedy, which is usually given for breach of a condition, or remedy given for the breach of a warranty. So it's an intermediate. It lies between condition and warranty. And we know where it's actually tilted towards. Only after there has been an actual breach, then we look at the effect of the breach. Then you also come and talk about exclusion clauses, exemption clauses, where one party seeks to minimize or reduce, or even something completely say that I'm not prepared to be held liable in the event that I'm in default or in breach. Such a practice, as we know, undermines the principle of party autonomy or freedom of contract. And for that matter, the common law has always had a very stiff attitude towards that. So a very high bar is set before the court will recognize such exemption clause, exclusion clause. There must be evidence that it properly formed part of the contract. So there should be evidence of proper incorporation, okay? So how do we know that the exclusion clause actually formed part of the contract? Where the contract is in writing, as if you sign, then it means that you knew what you were signing. So that is evidence that the exclusion clause was properly incorporated into the contract. and so on. Of course, we have exception. The exception of fraud, and like they remember the interesting case was the Curtis chemical cleaning dyeing company. The woman who was deceived regarding the wedding gown. And also the non ex factum is not my deed. So apart from those exceptions, the general rule is that once you have signed, then it's presume that you have accepted what you signed. Then again, where the exemption clause is not in writing, how do you establish that it was incorporated into the contract? The position of the law is that reasonable and adequate notice should be given of the existence of the exemption or the exclusion clause before or at the time the contract was actually being made. And so the other party against whom is going to operate must be aware of it before or at the time the contract is being made and not after. And remember the interesting case of where they entered the hotel room before they saw the writing supposed to be the exemption clause there. And later on, when their things got lost, the question was whether the hotel could be protected by the exemption clause. And the court said that the contract was made at the reception point, Olay and Marlborough. And so therefore, the exemption clause had not satisfied the requirement of incorporation as forming an integral part of the contract. So when you've gone through all this, then the next thing is where the court is being satisfied that yes, the exemption clause forms part of the contract, the court needs to also interpret whether the exemption clause actually covers the particular breach which has been occasioned. And here, the exemption clause must be clear. So where it is not clear, but there's an ambiguity, the court will have to interpret it. And the court interpreting an ambiguous exemption clause would, among other things, use what we call the contra proferentem rule. That is, if there are competing interpretation, the court will go for the interpretation which is to the disadvantage of the other party at whose instance the exemption clause was included in the contract. So let us keep that in mind. And of course, there's also this issue of whether exemption clause is affected by the so-called the doctrine of fundamental breach. The case of photo production and secure record, the House of Laws had definitively pronounced that the doctrine of fundamental breach is no longer applicable to exemption clause. The doctrine of fundamental breach used to be that when there has been a breach of a term of a contract, which is so fundamental, so that the contract is to be repudiated, then it affects everything in the contract, and you cannot even make use of exemption clause in order to escape liability, as it were. But photo production against security, guys, remember the story, the fire, exploding when the security guard lit, where he was supposed to be guarded. Remember that story. The House of Law said that, well, as whether exemption clause is applicable or not is not just invoking fundamental breach. It's a question of construction. You just construe, interpret the wording of the exemption clause vis-a-vis the contract and what has happened, and then you know whether it's applicable or not applicable. So in a nutshell, this is what you should know when it comes to terms of contract.
We are most grateful, my Lord.
Okay.
My Lord, coming back to chieftaincy, again on the supervisory jurisdiction of the High Court, there is confusion as to whether, as part of the review of the remedies available, the quo warranto is part of the remedies that the High Court could.
A co-warrant, oh, sure. So when it comes to supervisory jurisdiction, as you rightly said, where as a general rule, as a cause of matter affecting chieftaincy, the regular courts will not have jurisdiction. If jurisdiction will be exercised at all, it has to be the judicial review. And judicial review as to whether they have stayed within their jurisdiction, whether they have respected the principle of natural justice, and so on. Now, the court, in doing that, as you rightly said, will deploy what we call the prerogative rights, including certiorari, where on the face of whatever record or ruling that they may have, there's a manifest error of the law, which is patent on the face of it, or whether they have exceeded jurisdiction, they don't have jurisdiction, or things like that. Then the court will issue certiorari. Then prohibition, for example, where the court has made the determination that, let's say, a panel member of the judicial committee of the original House of Chief, for example, is conflicted. Okay, let's say that he is caught by one of the rules in the natural justice, so that it is not fair for him to be part of the panel to hear and decide the case. So the court has actually gone to it and issued prohibition against such a person. Then he is prohibited. You have to step aside for them to put another, if you like, a panel member there, as it were. And then the co-warranto, as you rightly said, where a body is dealing with something which it does not have authority to do, then the court will issue that to challenge the body to come and explain the basis of the authority that is purporting to exercise. Or yeah, so that is it, Elizabeth.
Thank you, my lord.
Okay, I think I'm going to draw the curtain down. So I presume you don't have a lot of questions. So tomorrow I'll just come and talk to you, and I'll not allow you to speak. You just listen to me the whole time. Yeah, thank you.